Mr. Mort is a pension fund lawyer with over 25 years' experience. He headed Edward Nathan Sonnenberg's Cape Town employee benefit practice before starting his own practice in 2009. Mr. Mort has furnished opinions to retirement funds on almost all areas of the law relating to retirement funds. Mr. Mort is a past national president of the Pension Lawyers Association, sits on the Actuarial Society Professional Conduct Committee, and acts as legal advisor to the Tutu Foundation. Please welcome to the stage, Jonathan Mort.
Ooh, he looks quite rough in that picture. You've cleaned up. You've cleaned up. Jonathan Mort, 20 minutes with Jonathan Mort, then your questions. Anything on governance? Prepare your questions, please. We'll take your questions from the floor. Also, I've got a couple on scraps of paper as well for you.
Good. Thank you very much. Well, it's great to be here with you. I mean, I know the main focus of this is around investment issues, but my broader interest is actually in good governance of pension funds. You cannot divest the two from the other. And so this is the topic of my talk this morning. Specifically, I was asked to talk on this. These four specific items. Why is it so important for trustees to understand their fiduciary duty to members? How do you measure good governance of pension funds? What should you look for when assessing the governance arrangements of umbrella funds? And what are the risks for employers and members in umbrella funds? So we start with the first issue, a fiduciary duty. Okay, and it may sound odd to you that in fact there is a fiduciary duty because there has been a dispute amongst the pension fund industry about whether trustees actually owe a fiduciary duty to members. And it's critically important, firstly, that trustees really appreciate that. You would be amazed at the many boards that I've sat on where that is not actually so crystal clear to trustees. They think they have obligations to their employers, to their unions, and they're there just to do a job of looking after money. The fact that members have a real and direct interest in what they are looking after is sort of beside the point. So in this key case of Phillips versus Fieldstone, it was stated that a fiduciary duty exists where there are three situations which apply. The one is where there's a scope of for the exercise of some discretion or power by person A in relation to person B. This power or discretion can be used unilaterally by person A and affects person B, and person B is vulnerable to how person A exercises that power. And once you understand this is what a fiduciary duty is, well, it's pretty obvious that it applies to every single trustee of a pension fund. It doesn't matter whether it's an occupational fund or retail fund where people voluntarily put their money. The fact is all members stand in relation as person B to person A in this particular paradigm. So the fact that trustees owe a fiduciary duty is also confirmed in two important Supreme Court of Appeal cases, and it's also stated overtly in the preamble to Regulation 28. David mentioned earlier that in the General Law Amendment Act, which is making a whole lot of alterations to the Pension Funds Act, there's going to be a strengthening of this, and that is very good news for people who want to see governance strengthened in pension funds, and that will be it will be very good to clarify all of that. So importantly, the fiduciary duty is owed by trustees in respect of accrued benefits only. It's not owed, interestingly, in relation to surplus. That's why you can apportion surplus to the employer. And importantly, when it's owed, there are three serious consequences for the trustee. The first is that there's a duty of loyalty, which means you cannot have a conflict of interest situation, and that's why talk of simply managing conflicts of interest is really problematic. Secondly, there's an accountability obligation by the fiduciary to the member. And thirdly, there's an automatic duty of care of the trustees towards the beneficiary or member. And that duty of care is very important because in law, if you want to hold a person liable for a loss you may have suffered, you have to show, firstly, that you've suffered a loss, secondly, that that other person caused the loss, and thirdly, that there was a duty of care. And often establishing the duty of care is really the problematic part of that. You think of an accident on the road. Who owes who the duty of care? When you are putting out, manufacturing some gizmo, do you owe a duty of care to the end user if they don't use it properly, and so on. So in my sort of paradigm, and I hope this is what's going to be in this General Law Amendment Act, the emphasis will be that trustees owe a fiduciary duty to the members, but they also owe a secondary duty to ensure the financial soundness of a pension fund. On to the second of those 4 topics that I've been asked to talk about. How do you measure the good governance of pension funds? Well, there are 4 purposes and outcomes which every trustee must seek to achieve. And if you remember anything today, it's please will you remember these. These 4 purposes are: 1, that the benefits promised by the fund are actually delivered. Secondly, that the benefits are optimal within an appropriate level of risk. Thirdly, that the cost of providing those benefits is transparent and justifiable. And fourthly, that the process of providing these benefits can reasonably be trusted by the stakeholders of the fund. So, you know, you may do all of the first 3 of those, but if you're having a massive volume of complaints before the pension fund's adjudicator, you're actually clearly not succeeding. And the costs issue is one that is now coming very much to the fore, as we've seen with this costs paper. And, you know, the issue of exactly what the benefits promised by a fund in the context of a DC fund, those is something that trustees need actually to work out. But what is particularly important about this is that it's not only the trustees who should be aware of these 4 purposes of good governance, it's also the sponsors of those funds. And we'll get to that when we talk a bit about umbrella funds shortly. So these 4 purposes should inform the trustees about every aspect of what they do as trustees. And essentially, you can divide this into 3 areas. You'll see it in PF 130 like that. It's how the trustees actually govern themselves. How many meetings do they have? How do they take decisions? Who does what? And so on. How the trustees govern the fund business, which is how do they actually exercise oversight over the operation of the business, which includes the benefit administration, the investments, and so on, and then how do they manage their stakeholder relationships. So, for example, when they do their board appraisal, which they should be doing annually, they should be looking at these 4 purposes and saying, well, now, how have we as a board achieved all of these 4 purposes? When they look at their trustee remuneration policy, and every board, many boards these days actually do remunerate their trustees. And there was a question asked earlier about trustee remuneration. In my view, it's going to have to go up significantly. If you pay trustees peanuts, you can only expect to get the monkeys, as they say. So, but the point is, when trustees get remunerated, are they getting remunerated to do what they are supposed to do, which is in those 4 governance objectives? It's how they arrange their investments, how they manage their service providers, how they communicate. So, on to the third issue, what to look for when assessing the governance arrangements in umbrella funds. Well, there are 4 main areas, and I'm talking here specifically around commercial umbrellas, which have a commercial sponsor and a commercial proposition associated to being the sponsor of those. It's the quality of the board of trustees, it's the quality of the administrative systems of the benefit administrator, it's the investment arrangements, and it's the costs. It occurs to me that there's actually a 5th one as well, and that is exactly what is the nature of the relationship between that sponsor and that fund. And specifically, how does the sponsor generate its profit from this whole arrangement? So let's look at firstly at the board of trustees. The independent trustees must be genuinely independent. I know this is a real concern for many, for the registrar at the moment, that many of the so-called independents are not actually dependent because they're there to be compliant. They have a job which pays them fairly well, and if they rock the boat, then it's a problem for the commercial proposition around the fund. So that is something that needs to be very carefully assessed by anyone wanting to assess an umbrella fund. They must be at least half the board, and they must have experience and expertise. Now, importantly, and I think this is an issue which has been largely overlooked, mostly the sponsor trustees are operational trustees in that they're immersed in the actual business. But you know, we tend to concentrate only on the experience and expertise of the independent trustees, but how good actually are those operational trustees at what they do? And then, especially, the board must be able to demonstrate that fourth governance purpose, which you may remember is that they're able to deliver the benefit promise in a way which can be trusted. Now, the second part of this, what you look for when you look at umbrella funds, the benefit administrator's operating system. We've had a number of scandals recently around funds which have lost massive amounts of money having to do data rebuilds because the operating system was completely inadequate. And it's very, very complex to administer an umbrella fund. It's far more complex than an RA fund, a preservation fund, or an ordinary single employer occupational fund. It just is. You've got a whole cluster of different employers contributing at different rates. Usually there are different risk benefits applicable. Usually many of these employers are not very good about making payment of their contributions. And one important question you can ask is, how do they manage their unallocated contributions? PF 130 actually requires this, and as far as I know, very few trustees actually consider it, that there be a regular review, preferably with the assistance of independent external advisors, of the information processes, operational software systems, and accounting and financial reporting systems involved in the operation of the fund. Now that is directly out of the OECD Guide to Good Governance of Pension Funds. And you know, you cannot overstate the importance of proper IT governance. It's in the King 3, one of their 9 principles, and it really is very important. Then on the investment arrangements, how does the sponsor benefit from the investment arrangements of the umbrella fund? As far as I can see, this is usually where the money is made, and sometimes it is an appropriate way for them to make it, but you have to be very careful about where there might be a secret arrangement, and I have come across this in the commercial umbrella fund environment, where there are secret arrangements between a fund and the sponsor about effectively captive investment arrangements. In particular, the default option may not be an appropriate one, and if there's member investment choice. And what one needs to look at where there's member investment choice is the proportion of members who are actually in the member investment choice. And if it's very high relative to the membership, then one has to ask why there is an expensive burden in the fund of having member investment choice at all. Because very often that could be precisely why there's member investment choice, so as to add a layer of costs which are borne by the general membership. Then finally, around the investment charges, are those fully disclosed and benchmarked? And is the investment performance stated as being after investment costs and against both an appropriate benchmark and inflation? Usually the reporting, from my experience, doesn't actually do it like that. It's usually on a gross basis. and as Stephen has highlighted earlier, that it's just not worth comparing then, considering it. Costs are particularly important in umbrella funds. They're very complex. They have a much higher level of costs because they have independent trustees who have to be paid. They have far more onerous auditing requirements, and they have much more complex investment arrangements usually. The big thing is, can those costs be compared with other umbrella funds? And in my brave new world, it would be the regulator that stipulated that there has to be a disclosure to the employer and to the members about the rand amount of costs per annum, per member, as on average, and also as a percentage of fund assets. Every type of cost computation must be able to be reduced to that. And if the regulator required it, and we could have statistics published annually about what the average cost was for investments in large and medium and small funds, retail funds and umbrella funds, we would go a long way to actually having some market equalization of this asymmetrical information that we've heard about. Now, the role of the employer and umbrella fund is actually, in my view, far more important than in a single employer occupational fund. As you know, it's the employer, not the members, who determine which umbrella fund that employer participates in, unless it's a union fund. But usually it's the employer that determines, as I say, unless it's a union fund. It's important for an employer to do a due diligence. Very often, it could simply be that the employer is told this is the fund that will give the right investment options without any regard to how capable the underlying operational systems are, without any regard for a cost comparison of the actual costs, whether the investment arrangements are in fact appropriate for the profile of the fund membership. And it's possible, if you look at that definition of the fiduciary duty, that an employer may in fact have a liability if they didn't do a proper due diligence, and there's a subsequent significant loss for the members. So this is the final, right near the end, and I've well within my time, I see. The main risks are, for members and employers, that there are poor benefits, that because of poor governance, their loss suffered, which results in, compounds the poor benefits, and for the employer, that there are poor employee benefits because pension funds are part of the employee benefit offering. They'll have disgruntled employees, they'll not be able to attract good employees, and so on. And if there's anything that you remember from today, it's these 4 items. Trustees owe a fiduciary duty to members. Trustees must understand and apply those 4 governance purposes. There are significant costs and risks in umbrella funds, and the employer has a particularly important role in ensuring good governance in umbrella funds. Thank you very much.
There'll be more on the issue of umbrella funds after the tea break this morning. A couple of questions coming through from you. Administrator and asset manager independence, should they be separated?
Not necessarily. I mean, it all depends on what the impact that will be on costs. Mm-hmm. And it all depends on how confident you can be that they'll be able to do both jobs equally capably.
All right. But under what circumstances would you separate? In terms of, would then become to the ability?
I suppose, I mean, you need to look at them separately. Mm-hmm. So you need to have a sense of assurance about their investment capability. And I mean, if they were active managers, you would want to be sure that they were not being distracted from the administration work by focusing on the exciting, sexy work of
trying to generate
alpha and all of that.
Trying to get a return.
So you need to make sure. I mean, for me, I've been particularly involved in seeing the disasters around the benefit administration. So I would really want to be satisfied they can do the benefit administration properly. If they can do that properly and doing the asset management is not going to distract them from that, then I would say it's probably fine.
Okay.
But in that sort of following that thought process.
With regard to PF 130 requirements to have an independent assessment of admin systems, the sponsor controls costs. So how do trustees manage to arrange such a review if a sponsor refuses?
Well, you see, that's a problem then. Because why should
Change
the sponsor
sponsor.
case... No, but why should the sponsor control the costs? The trustees should be there to do what they think and to incur such necessary costs as they think is appropriate. I mean, you could say then that if that was the approach of the sponsor, that, well, they couldn't get legal advice. They couldn't do this or that. And that's patently wrong. I mean, trustees have to be able to do what is necessary.
They must control the process.
Indeed. I mean, it may be that they should, as a matter of process, discuss it with the sponsor because it's going to impact the commercial outcome for the sponsor, but it is the trustee's decision.
And then how should trustees monitor admin systems? It's a broad general question. Maybe you have a specific intent, but is there a specific way of managing admin systems?
No, there are a number of things you can actually do. Firstly, you need to get a sense of comfort around the level of reporting. Secondly, there are some red flags which come up very quickly if there are problems with the admin system. The one is delays in benefit payments, delays in delivery of annual benefit statements, and the third is delays in production of the annual financial statements. And all of those are red flags which trustees should take very, very seriously. You can also verify that the reporting is correct in certain ways. You can check, for example, that what the asset manager is telling you is in fact correct with what the custodian tells you. You can check with, see a copy of the bank statement to see that in fact it does correlate with what the benefit administrator is telling you in the bank. So there are things you can actually do.
Don't trust them.
Well, you need, it's not unhealthy to have some...
Healthy skepticism.
Healthy skepticism. Because in the end, you're relying on them. And in the end, you're the one who's going to be responsible if they don't do what they are supposed to be doing.
And mistakes happen as well.
Of course they do.
Yeah?
Yeah.
Absolutely. Any questions from the floor before we break for tea? Any questions? Any questions? Any questions? I have one final question before we go to your final question and your final question. So two final questions from the floor. For the people in this room, when you look at the risk, the increased risks that trustees are required to take versus the returns they can generate as paid trustees, what should that risk-reward ratio be, ideally? Is there a formula?
I don't know that there's a formula. I think they need to be paid properly as a professional. And I suppose, I mean, most trustees operate in a non-executive function. So it's a non-executive role they play. And I suppose the only comparable charge rate is what do non-executive directors of companies get
They face
paid.
similar liabilities.
No, they probably face a greater liability.
So they should be paid more.
Yeah, they should, depending on the level of expertise that's required of them. But that's why I said, you know, I think you're going to have to pay them properly, and you're going to have to bear in mind that this would have an impact on the board dynamics as well.
Yeah.
Because you're going to have some trustees who paid and others who not paid or not paid so well. And you have to have a board that's able to operate functionally and not be dysfunctional and discount everything that a so-called expert may be saying or resent what a so-called expert may be saying simply because they're being paid. But you do need that expertise, and it should be paid for in fairness. You can't expect people to do something for nothing.
Your question.
Jonathan, one of the points you made was that trustees should look at where the profits, where the commercial umbrella sponsor is obtaining his profits from, but you didn't expand on it. Could you just expand on it a little?
Yes. You know, firstly, there's nothing wrong about having a commercial imperative associated with a fund, but it's how you actually achieve it that's so important. So if you're going to set up a commercial umbrella fund on the basis that, well, all the investments have to be done through me, and I'm going to make sure that the charge rate, the asset management rate is on a retail, not on a wholesale basis, for me that's a problem. If you're going to set it up on the basis that all the associated services have to be provided for me, by me or my associated entities, like the actuarial work, the consulting work, and so on, so that there's no real competition and there's no real way of assessing that these people are doing the job properly, that's also a problem. I think you need to make sure there's a measure of transparency around it, about how they actually make their profit, and also that it's appropriate. So a one-stop shop can be really problematic for me, even though I'm aware you can actually save costs, but I'm not aware that it does always save costs, because it becomes like a big warehouse where a whole lot of stuff happens without a real market discipline being applicable. I think it's quite, but you know, I think that's really up to the consultant to actually take an assessment about that. This is where it's an appropriate arrangement. They can't really make an assessment. You can't really expect the employer who's, I don't know, doing building work, for example, to understand whether the profit imperative associated with this and the whole way it's set up is appropriate. But it is a very important issue.
We're going to be talking about the role of the consultant just after the tea break. Second last question over there, then absolutely the last question over there. So can you wait for the microphone? Sorry, it's just there's not great acoustics in this room. Thanks.
The sponsor-appointed trustees, should they be paid? And the second question is the relationship between the sponsor and the fund and the trustees. You touched on it slightly, but I'd like you to expand on it a bit more, because I get the impression that the sponsors have more control in certain cases than the trustees do. And how does one actually handle that?
Thank you.
Yeah. Those are really good questions. You know, if the sponsor trustees are also people acting in the operation of the sponsor's business, I wouldn't see that it's appropriate for them to be remunerated separately from their obligations as employee. So in a sense, they're acting as trustee, a bit similar as an employee, an employer-appointed trustee of a single occupational fund. I mean, they're there in a sense as operational trustees very often to explain what's happening within the business. So even though they're employees, when they sit there as trustees, they're principally trustees. I just think I haven't really thought about that. I mean, you could pay them, and then you could be more exacting about them. I know, humanly speaking, sponsor trustees, it's very difficult for them to wear the trustee hat. They're always sitting there as people thinking about the business. Whether paying them from the fund is going to make a difference, it could make a difference.
Aren't they double compromised then? Because now they're taking an incentive while they're taking two lots of incentive.
Yeah, I don't know.
It's
a very good question. I mean, let's see. I'm averse. I'm personally averse to loading more costs. You know, if we can have them without having costs, so much the better. You don't even need to have a sponsor-appointed trustee after all. You can have the sponsor present at the trustee meeting, but there's no real need for them actually to be a trustee. So that would probably be my answer, that on that basis they shouldn't actually be remunerated.
There we go. That's perhaps the solution. Absolutely.
But there was another point. Sorry, just that.
That sort of solves that problem.
Well, no, I think not quite, because I think there should be an express contractual relationship between the sponsor and the fund, so that each knows what is expected of each. It's an open contract, not a secret one, and it's very clear in what circumstances, for example, the trustees can consider a different benefit administrator or different investment arrangements outside of the sponsor's offering, and things like that. That's very important.
Machine shouting at us.
Yes, I see.
Okay, I'm just going to be quick. We've been having this argument whether, in terms of paying trustees, because then you have employer and employee trustees, and they are there in those meetings during the employer's time. Now, if you're going to remunerate them, you're remunerating them double. How do you then deal with that issue? Because as well, when you then start saying, as you've mentioned earlier, that you're then paying the trustees fairly, how do you then determine that amount of being fair? Because then at the end of the day, it adds on to the fees that the fund is incurring, and that's taking away from the members' contributions.
Fabulous question. Tough audience.
Well, the tougher the question, the better. Look, remember, we're talking mainly about umbrella funds here. And I think what would be really good at some point is if we ensure that there was member representation on the boards of umbrella funds. At the moment, there isn't, generally speaking. But I take your question to be one specific mainly to the single employer occupational fund. And I agree with you that people shouldn't be paid double, but only if then they don't carry additional risk. So to the extent that they are being indemnified by the employer or the fund and they don't carry personal liability, then I agree completely with you. Why should either the employer trustees or the member elected trustees be remunerated?
Do they then, but is there the same level of incentive to give the best possible input if there is no personal liability? Because personal liability keeps you sharp.
It does keep you sharp. I mean, you may have an indemnity, but you'll still have a reputational issue.
Yeah.
And I think that's probably...
Assuming the members know who the trustees are and understand what it is that the trustees do.
Yeah, yeah.
In the first
and hopefully one day the registrar will also keep a record of who all the trustees are and actually ban certain people from being trustees if they've participated in failed funds, as it were.
Who would you like to see banned? Jonathan Mort. Thank you. We have a paramedic at the back for precisely that moment. Jonathan Mort, thank you very much.